Was that 5 seconds?
Yeah, I'm looking at the YouTube stream. It's not on yet.
It's on.
It's on.
It has the delay. All yours, Martin.
Yeah, excellent. Thank you all for joining us, and especially thank you, Anna, and thank you, Noah. And Noah, you're up really early. You were promising me to join in pajamas. I think you chickened out, but it's fine.
I did chicken out in the end. I wasn't sure how it would be.
No, but it's great. Thank you both of us for joining. Today's topic is AI for lawyers, as in the broadest sense of the terms. Of course, it also happens to be the title of Noah's recent book. It's not going to be all about the book today, but it's going to be at least partly about the book and some of the ideas that Noah has put out there with his colleague in the book. But I think we should just have a brief introduction. Just as for Martin and me, I can say we represent the Legal Hackers chapters in Stockholm and Copenhagen, respectively. And Anna, would you like to say a few words about yourself and your background?
Yeah, hi, I'm Anna Ronka, and I'm also the founder of the Helsinki Legal Hackers chapter. But I've been an AI and law researcher for about 20 years. So I couldn't decide, or I wanted to do something with law and computers, and made some jokes about electric chairs back in the day. But when I went to study both electrical engineering, computer science, and law, so that was the kind of the obvious combination like 30 years ago. But then ended up getting a professional career in software development and an academic one in legal theory with a kind of an AI focus. And most recently, I co-founded the legal tech company Trademark now in 2012. Worked there for 5-6 years as the chief scientist, and then pursued greener pastures for a few years. So the company got sold to Core Search last year. So it's doing very well.
Excellent. And you, Noah? Few words.
I'm Noah Weisberg. I'm glad to be with you. I'm sorry not to be with you in person. I guess it wouldn't be possible to be with all of you in person at once, but Copenhagen and Stockholm, I haven't been to, unfortunately, as many of the other Nordic places, but I really like those cities, and I'm sad not to be with you in person for this. I started my career out as a corporate lawyer at Weil Gotshal in New York. And I spent about 4 years in that job. Thought there was opportunity in the idea that junior corporate lawyers spent huge amounts of time doing work that they weren't that good at, that was highly repetitive, that clients hated paying for, and quit. And after a bit of reflection on how best to approach that, started Kira Systems. Kira Systems grew from sort of 2 people in January 2011 with my co-founder, Dr. Alexander Hudek, and I, to 4 people, sort of still bootstrapped in 2014, to 8 people by the end of 2014 when things started to work, to about 30 people by 2016, more than 100 people when we raised money in 2018, and we're now about 200 of us. Our software helps people pull data out of contracts faster and more accurately. Most of the world's best law firms use our software, so many people use it for mergers and acquisitions work. In mergers and acquisitions work, 18 of the top 25 firms in the 2020 M&A league tables used our software. Unfortunately, not on every single transaction, but we're working on getting to that ubiquitous use. And that includes some really good Nordic law firms. So I don't know if we can say the one that you worked with in Denmark, but one of the best Danish firms, and I think 2 of the best Nordic firms are our customers, as well as a whole bunch of other firms in other places.
Excellent. Thank you, Noah. And sticking with you, since you had the audacity to write a book with this,
You might even have the first one, right?
with this topic, AI for lawyers. Yeah, there's a children's book too, right?
A children's book, right?
Yes.
I believe I am the author of the world's first children's book on machine learning. But
excellent. They will need
a lot
it.
less time to write than this one.
Well, AI for lawyers. So we are of course, at least some of the guests and a big chunk of the participants here are lawyers. So we need definitions, of course, Noah, and then please define this AI thing for us. It strikes me that the definition you use in the book is probably a bit broader than people might think.
It is. We've seen a lot of debates over how wide or narrow AI should be, and to be honest, until probably 2015 or so, my co-founder Alex and I had a lot of trouble with the term artificial intelligence because we felt like it was so broad, and we preferred using machine learning at the time. But at a point, we decided to embrace it and give it. And where we came out is that artificial intelligence is anytime you have a artificial system, right? So probably a computer that's doing something that a animate, probably a human intelligence would otherwise be doing, right? So, for example, if you have a computer basically doing a human-like task, that is artificial intelligence. So the kind of corollary, and Martin, you point out that that's a very broad definition, is do things like rules-based or expert systems or even rules-based natural language processing fall within artificial intelligence? And in that definition, they do. And it's sort of interesting for us as a company because in the early days, we had sort of a big disagreement with one of our competitors who had more of a rules-based approach to solving the same problem that we had decided to focus on using a machine learning approach. And the reason that we sort of got comfortable with this broader description of AI is that from a user's perspective, it doesn't really matter what's going on under the hood, right? Like from a user's perspective, they don't care how you solve the problem. They just care that there's something that is replacing their human intelligence with an inanimate one. And that's why we thought the broader definition was kind of right. And ultimately in the book, and I think in real life, it's just not a topic that animates us that much. We'd rather get on to work and not fight about that.
Okay, that makes sense.
I'm not criticizing anybody who does. Like, there are certainly people whose job it is to think about that more thoroughly than us. We thought for us, and actually readers of the book, that there were just better things to try to spend our energy convincing people of, like specifically why they should use AI.
But yeah, there are of course some implications that come with the technology that you use when you use machine learning and neural networks and some of the limitations and possibilities. But I hope to get back to those later, because they might actually, the substance of those might be worth understanding as a user. But we'll get back to that. And what's your thinking? What is a useful operational definition of AI in the space that we're operating in relation to law firms and their use of such technology?
Well, I would really, yeah. I mean, for the use of law firms, I don't think whether something is called artificial intelligence or not, that has approximately zero relevance. So for me, I think that really what artificial intelligence is, it defines a research agenda, which is doing things with computers that people are at least somewhat good at and computers cannot do at all. So kind of AI started as a more as a project of understanding human cognition through computational methods, and then of course then of course you can do useful things with it. But whether something is called AI or not is not really that interesting. It's whether you can do something useful. That's really the crux.
Okay. Well, that's interesting. So, in terms of when we then look at those technologies that fall broadly under this umbrella, and what's your thinking on what makes the challenges and the possibilities that those technologies present? How are they special when you try to relate it to work related to the law? What are some unique, if any, characteristic of that sort of combination? What problems comes up uniquely when you try to combine the law with these types of technologies?
Well, there are. I mean, of course, there's no. I mean, general artificial intelligence, of course, something that's mostly for science fiction nowadays. So obviously, any problem you address is something that you need to do specifically to address that particular problem. So of course, some tasks are more general than others, but something like natural language processing. I mean, legal language is in some sense it's sort of very regimented, supposed to be very similar in and it is highly standardized. But on the other hand, if you compare it to ordinary language that normal tools are more sort of general purpose language technology tools are built on, it's much more complex in terms of sentence structures, which we of course all know that we have sentences of 50 plus words and so on. So it's very different, a kind of different beast to process. But I think kind of the big challenges are more in simply sort of those very practical terms of you actually have to do things to accomplish them, and so it's a very fragmented field of small problems that in and by themselves can be very complex and not necessarily worth solving, or at least not worth solving well. So that's really, I think, what's the main challenge with AI and law is that it's a lot of hard and often quite boring work that you need to undertake to solve some particular problem. And of course, in Europe we have the added fragmentation of different jurisdictions, different languages, etc. And especially in our region, I think that's the main challenge, that legal technology solutions often exist for English and the US legal system, maybe a few other common law countries, and that's it. And then for us they are useful if we deal with, and of course in like corporate law, a lot of things are in English and even under jurisdiction of Delaware or whatever, but so a lot of these things are very useful, but not necessarily so generally useful. So that's of course where something like legal hackers is very important in trying to kind of stimulate this kind of activity throughout the world, not just in the US.
So Noah, what's your thinking? I know at least in your book you touch upon topics like confidentiality as something that's at least has been a huge part of people's considerations about applying these types of technologies, and also professional competence and duty of care and so on that you have as a lawyer. Of course, these are not identical across jurisdictions, but there's something equivalent to that almost everywhere. So, and if that has any bearing on the use of these technologies.
So the overall tricky thing is, like, there are technical difficulties in many sub areas that you might focus on, right? Like if you're focused on document classification, the technical problems are probably less research-based ones, right? Because there's been heavy research on that type of problem. The specific problem that we started out on, pulling data out of contracts, turned out there's sort of maybe a lot of research and commercial development on things like entity extraction, but a lot less when it came to things like finding legal clauses. And in our particular case, we found the state of the art when we started just didn't work as well as we needed it to in our area. There are other problems, though, that are not necessarily technology research-based problems, that there are those, and we have a not small research team who works on getting the technology better. But a lot of the thorny problems are things like, how do you get lawyers to do things that different, especially when they're relatively successful, they believe, at doing things the way that they're going right now, especially in situations where lawyers bill hourly and sometimes have a complicated relationship with technology that makes them go faster, especially in situations where they may be very worried about client, and rightly, about client confidentiality. As Anna points out, it can be very hard to get documents from in foreign languages, or foreign. They're all foreign in a sense, but in non-English languages. It turns out it's fairly easy to get large amounts of English language contracts to train on, and exceedingly hard. In my experience, though, I'm very open to suggestions to get languages or contracts, large numbers of contracts in other languages. So I think there are a lot of problems around the technology itself that can be very tricky.
Yeah, I've made the same point about the confidentiality, and that kind of makes it very difficult to access these kinds of documents that you need in order to train these kinds of systems. And of course, you can then take it as an extra problem of using computational methods to anonymize the contracts in a way that you can still use them, but they don't reveal anything. But that's just another problem of almost a similar complexity as the problem you were trying to solve originally. So yeah, these kinds of non-technical constraints are, I think, and then also questions of indeed attitudes. I mean, with the trademark now, the idea was to in part to move some of the work that was done by outside law firms, to move that into the companies that own trademarks as they clear new ones, and even from the legal team inside to the company to the marketing team, so that they can do when they brainstorm new trademarks, they can use the tool already in that context, and they can kind of get rid of the non-working ideas as early as possible, but kind of instituting that kind of rethinking of the processes is very, very difficult, and that's kind of, you don't really want, if you don't want to be doing, if you've been doing things in a certain way and now you want to add AI for whatever reason, the idea that you can keep doing things the exact same way plus AI is not a very good idea.
But is this? I know, of course, you pointed out the problem of the hourly rate and so on, and that tension between becoming more efficient as a lawyer. But are we? Is both of your perspective also that putting that aside, that lawyers are especially resistant to change if you compare them to other professionals and so on, or is it a general phenomenon that if I was to try to introduce like AI-based technology in like a consulting firm or whatever, would I see the same kind of change resistance, or are we dealing with a special case of extraordinary aversion to change?
I think it's tricky. I think that in some ways lawyers maybe better than others at adopting technology than we give them credit for. So, well, I think lawyers can be tricky to get to adopt new technology, and that hourly based billing doesn't help. That we've definitely noticed in areas where people are doing fixed fee work that they seem, so for example, in the UK or limited other places, M&A work is often done on a fixed fee basis, and we've noticed in those places it can be easier to sell Cura usage because people are sort of a problem that partners at law firms face is maybe they're losing money on due diligence or something like that. And if they're losing money on due diligence, they can be a lot more receptive to the idea of trying to be more efficient at it than they are if it's not something that they're losing money on. So I think that makes an impact. But well, I think lawyers may not be the fastest to initially adopt new technology. And tricky there. There actually are a lot of examples, and we list a bunch in the book, where lawyers have adopted technology and new technology nearly ubiquitously. So a few examples that come to mind for me are electronic legal research. Right? Like once upon a time, my dad was a lawyer. Like his law firm had a floor in their building, I think, that was filled with like a law library. And that doesn't exist anymore, right? Like there are still probably the same number or even more law librarians, but almost all the research materials would be electronic now. I think about blacklining sort of comparison software, redlining, delta view, whatever you call it, comparison software, where I remember when I started as a lawyer, people who were partners when I started told me about how people had done the comparisons by hand, but not that long ago, and sent the comparisons down to sent two documents to compare down to the sort of secretarial pool and had the work done that way. And I spoke to one not long ago, and he was saying how in the early days people viewed the comparison software as being maybe inaccurate, and they worried about it. And by the time I was a lawyer, started being a lawyer in 2006, it's not something that we would have considered doing any other way. Similarly, virtual data rooms. When I started as a lawyer in 2006, virtual data rooms were being used. I used them sometimes on deals, but I also went to St. Louis, I went to Pittsburgh on deals, and went to a company and went to a room and pulled documents out of boxes. If I'd started 4 or 5 years earlier, I knew from talking to people, that would have been the usual experience. If I started today, or certainly in 2021, but even if I'd started in 2016 or 2017, all the time, maybe apart from once, I would have used a virtual data room instead of a physical data room. So these are examples of situations when lawyers have changed their behavior ubiquitously. And I don't know that that happens in every single profession. Like, if you ever read any of the, like an Atul Gawande book about the checklist manifesto about medical professionals and them doing things differently, like even there where you have exceedingly strong evidence in a lot of cases of better ways to do things, it's really hard to get medical professionals to change. So, well, I think lawyers can maybe be a little hard to get to adopt new technology initially. There is a really positive, shining thing with lawyers, which is that once they do adopt a new technology, they tend to do so very heavily.
Yeah, I think one interesting part of the two technologies that you mentioned there, data rooms and red/blacklining, is that they're also viral in nature, right? You are always pulling in like the other side somehow. If you can convince them that we are going with or back in the day you had to convince something to go with a digital data room, you automatically introduce the other side to that if they didn't have experience with it. Same goes with the redlining. And I would have, sorry, go ahead.
Well, yeah, I think part of the thing is, and I wouldn't claim to know what what Danish or Swedish or Finnish or other Nordic rules are on around providing good representation to your clients. But in the US and Canada, there's this rule that you have to provide competent representation to your clients. And I think at a point, the technology changes such that if you're not using the new technology, you're not providing competent counsel, right? Like, if you're not using electronic legal research, you cannot provide good, like the best legal research to your clients. And that's something that actually ends up putting you as a lawyer at risk. You put your clients at risk of not coming out as well from using you as they might have if they'd used someone else, and that's bad. But you put yourself at risk then, if your client doesn't come out that well, of them turning around and bringing a claim against you.
Yeah.
And I think for a lot of lawyers, as they realize that things could be different, it's kind of like medical malpractice or something like that for not using the best technology, right? Like, you can face a malpractice claim. And then what's worse, because many US states, actually I think 39 US states have a duty of technological competence, if you face one of those sort of legal malpractice claims, which is more of like an insurance-based claim, right, like a money-based claim, you then also potentially face a claim against you for your ability to practice, right? You won't necessarily have met your professional obligations. So I think that as things start to tip, those obligations can come into force and really help propel you forwards.
It certainly also applies to e-discovery, right? There are many cases that it's not possible to provide an adequate defense without using e-discovery in many cases, or prosecutor case for that matter. So I think that's a totally valid observation.
The other side of that equation is, of course, that in introducing any kind of new technology that may at that stage still be unknown, kind of how it works, how it fits into the process, etc. That is also a risk of sorts, and lawyers, of course, are known to be risk averse. So there is that on top of the question of incentives like hourly billing. And of course, law has traditionally a complex relation with technology, whether it's really there to help the lawyer or work as a marketing tool. So I always like to talk about the law firms 20 years ago having the fanciest photocopier in the office, and there's kind of that. So if you just introduce technology for the matter of kind of keeping up the airs of following with the times, then that's of course not a good recipe. But you have to kind of understand what you're doing and with what tools.
No, that's certainly true. I think I'd like to shift gears a little bit in terms of what these technologies, this AI. I personally am not super fond of that term. I prefer like machine learning, or even better pattern matching or something equivalent to that. But that's besides the point. I recognize how ubiquitous it is. In your book, Noah, there's a couple of places where you use the term understanding as something that the technology does. It understands natural language and so on. Just for clarifying here, for people who might not be too familiar with how the technology actually works, what is this notion of understanding that when it's used around AI? What does it mean for an AI system to understand something?
So I can't remember the exact page in the book where we use understanding, not helped by the fact that it's very early as well here, but I think as a general thing, I don't know, like, do AI systems understand what's there? Or are, as you pointed out, Martin, are they more just like you might teach a junior lawyer how to find a change of control clause by helping them understand what a change of control clause, like The broad idea is you have a company, and that company is becoming owned by another person, and so there might be a clause that describes there are a bunch of different mechanisms by which that company might come to be owned by another person, and there are a bunch of different ways that you might phrase something in a contract to capture that type of behavior, right? So if I was instructing a junior associate, I might try to explain to them the concept of change of control that way, and then I would probably give them some, ideally, I would, in a practical sense, I might not, but I would ideally give them some examples of how a change of control clause appears in the wild, and then set them off to work at it. Based on personal experience, I would probably miss a bunch of examples of what a change of control clause looks like, causing them to miss a bunch of examples what a change of control clause looks out. But that's what I do with a person. But with an artificial intelligence, it gets artificial, right? It learns it may get to the same destination as a human, but I think it arrived there via a different route. And I don't know, certainly in our system, I would not say that it necessarily I might colloquially say that it is understanding what a change of control clause is, because it can find one pretty accurately. But does it really know what a change of control clause is, and could it tell me about all the attributes? Probably not. I think we've given it a lot of examples, and it's really good at learning shared attributes from those examples. And one of the neat things about artificial intelligence is that it may pick up on shared attributes that even a person wouldn't. Like it's a computer, it can keep a lot of details in mind, and it may pick up on relationships in contracts, for example, in clauses that a person wouldn't. So where a person, if they were asked to describe a change of control clause, might define a rule, it could be that rule is under-inclusive. It could be that the rule is over-inclusive in a way that a probability-based computer program might not think of it. So anyways, I don't know that the artificial intelligence systems of today, at least the ones that we work with, understand what's in a document or what they're trying to do, but I think they may actually get to a result that is better than a person who does it.
Yeah, I would say that it's just a case of using a metaphor based on human cognition to explain what the computer is doing. So kind of anthropomorphizing what the computer is doing. So it's just like we can say that the computer is being moody if it does something unexpected, but of course the computer does not have moods. So I think it's just something we can say based on what we observe, that we give the system some kind of input, and then we see that it processes that into an output that makes sense to us in a way that demonstrates that the system has understood the issue at hand. That's basically what it boils down to.
Please continue.
Yeah, no. I mean, of course, there's a philosophical debate to be had, but let's not go there.
It's interesting. One of the interesting things to me is how much some of the analogies of human learning can end up applying. I was having a conversation with our head of research yesterday, and we were talking about a problem that we're having trouble solving, right? Like our software is not working as well on a particular class of problems as we'd like it to. And what he was saying is one of the tricky things for the people who were teaching the software is they were sort of teaching the software in the way they felt like teaching the software, as opposed to the way the software felt like learning. Like in this particular case, we're talking about trying to teach the software to find titles, right? And so a human's instinct when teaching the software to find titles would be, with Kira, you can highlight text and the software will learn from it. So that's how like a Nordic or a Danish law firm have trained Kira themselves to work in Danish or Norwegian, just by highlighting text. And so we were talking about how the instinct is when you're highlighting a title to just highlight the first instance of the title. But it's actually very confusing for the software because you may then end up, in other cases, maybe the title, it just is agreement at the title spot, and then in the preamble of the agreement, it might say this intellectual property agreement in the preamble. And so there you end up highlighting intellectual property agreement in the preamble, but you don't highlight it above the preamble in that position. And in other situations, it might say intellectual property agreement in both the preamble and above the preamble. And so if you end up kind of highlighting it inconsistently, or say you just highlight the first instance of it that you see, it actually can be really confusing for the artificial intelligence. And so it's a spot where, like, it's somewhat akin to how people are, right? Like, so often so many of us express a concept in a way that's easy for the speaker to understand as opposed to the recipient to get, right? Like, we're not as good at having empathy for what our recipients would like. Like, here we sit talking to an audience of people in the Nordics and Baltics, and I'm trying to explain things to you in a way that hopefully makes sense to you, but it may not, right? Like, there's probably a better way that I could speak to you, and I'm not. And I think it's the same kind of thing with machine learning-based systems, where they are learning, and we may not be teaching them the right way. I think it's a bit off on attention.
But it was also, I mean, it was kind of a mean question, because I'm asking about understanding in relation to machine learning and AI, and we don't even have like a good understanding of what it means. See, that got circular. We don't even have a good understanding on what human understanding means, right? We can't even, we can't really articulate what it means for a human to understand something even. So it becomes, it was just, I thought I found it sort of illuminating to talk about what it means. But I want to maybe move on to another term that's perhaps more precise, and that's explainable AI, whether or not something is explainable or not, right? Is that important, Noah, that a system like yours or similar systems are able to articulate somehow in a way that makes sense to a human why it has reached the conclusion that it has? Because I believe it's actually a challenge right now with some of the technologies that are used, right?
Yeah, it's a challenge that we've long faced, right? The nice thing about a rules-based system, for example, is you can say, here's the rule that we're applying, and everything that falls within the rule will get found, and everything that won't. So I remember an early, I think, competitor of ours saying that their system was 100% accurate, right? That everything that fell within the rule, it would find. Okay, like, that's a way of thinking about accuracy. We were pretty skeptical that in sort of, if you thought about it in a broader sense, like, it was 100% accurate at finding things within the rule, but was it 100% accurate at finding change of control clauses? We were skeptical. I think that ultimately a lot of machine learning based systems are not going to be that explainable, right? But you can't necessarily say why the software got to them, because in a lot of cases they're probabilistic, and the amount of like, some of the things may be easy to, some of the probabilities of things that they're considering may be easy to tell, but you can't get 100% of the way there. In the early days, we had a large client who was like a regulated audit firm, and they had to convince their audit regulators that the technology that their audit process was a good process. And for them, they really needed to be able to explain how they got to results. And with our system, they couldn't do it. And so initially they thought that a rules-based approach might be better for them. But what they ended up figuring out is that if they had a process for training the software, if they could explain how they taught the software, and explain that the results out of teaching the software that way were better than a rules-based system, that ultimately that explainability was good enough for their regulator and was good enough for them. And so I think that's often the best you can do. Like you can talk about, for us, if we're teaching the software, we could say, we've taught it on contracts from the US, the UK, Canada, but not necessarily Australia or India. Maybe or maybe not, right? But in a particular case, like we've taught it on contracts from these places, we've taught it on these types of agreements, we've had these types of people teaching it. Like, sometimes maybe even like we've had this specific law firm teach it. Here's the definition of what we're trying to find with it. If we can tell people that information, we think that is actually useful and important information to give, and that's about the best that we can give.
So, Anna, what's your perspective on explainability? Is it something that's important, and what is the future of explainability in your view in terms of AI?
Yeah. To build on top of what Noah said, I think the issue is really trust in the system, and I think explainability has kind of in some circles taken the role as a silver bullet for fixing AI, but rather I think it's a broader question of quality assurance, especially when AI/machine learning systems are being used to decide or recommend decision, for instance, that how do we actually figure out that the system is good enough to even be deployed in the first place? That what are the metrics that are relevant in that context? Then the kind of the role of explainability, I think, is mostly as a kind of a, well, in part it's obviously very important for the developers to understand what the system is doing continuously and what kinds of mistakes it is making, so you can figure out what to do about those. But also for the end user, I think the important role of explainability is when you understand that people and computers make very different kinds of errors. So if you have an explanation kind of outlining at least some salient points in the line of reasoning or just what kind of patterns the system has recognized, etc. If you have those salient points and anybody can say that obviously makes no sense. So in that situation you can start from scratch and kind of do the whole process without the system. So it's vital in understanding the limitations of the system, but it does not solve the problems it's expected to solve. I mean, some of the most talked about examples are something like in criminal sentencing in the US, and the problems there are a lot higher up in the food chain than the poor little piece of software at the end that is, well, being taught with all kinds of biased cases, etc. But even the biased cases are not really the crux of the problem, but rather the problems are much broader there. So obviously one of the lessons from that is obviously to kind of pick your use cases so they are not dangerous like that you are operating in a kind of an environment where the damage potential done is limited.
One thing that's really interesting about explainable AI, I can very much understand why people would like to have explainable AI when it comes to something like an AI that was deciding how to sentence someone or whether someone was guilty or not, how a judge might rule. One interesting thing that AI has raised, though, is that it can do a reasonably good job predicting how a judge might behave, right? And the judge might give an explanation. Like one of the reasons that we might like judges is that we can sort of understand the process and they might give an explanation and we can feel good about the explanation. But if a judge is giving an explanation and in the meantime we have an AI explanation for their behavior that may be different than their own explanation, but the AI one is pretty accurate, it kind of raises questions as to whether the judges, whether, even though they're explaining themselves, whether they're explaining themselves correctly.
Yeah, and it's certainly true that you can't. I mean, even if a judge is able to very eloquently try sort of express his or her reasoning around something, it's not it might very well be a rationalization after the fact, right? And it's certainly it's not likely to express that person's personal biases in any way, because if they're aware of them, they will not feel like expressing them, and if they're not aware of them, they won't be able to, right? So it's an interesting perspective, but it also speaks to how important the context of where you use these things are, and where you can sort of safely lean back and say, well, I can demonstrate to you that this thing is accurate. So maybe you shouldn't care so much about how and why it's accurate, and in other contexts it becomes quite important that it's explainable. But it segues, I think, neatly into a question I wanted to ask about post hoc and sort of ex ante use of machine learning and AI. It seems to me that a lot of the use cases we see at the moment are sort of after the fact uses of AI and machine learning. We're able to classify, illuminate whatever certain aspects of something after the fact. In your case, contracts that used for due diligence or other purposes, or considering a transaction and so on. But is it a coincidence that? Or am I right in saying that a lot of it is focused on sort of after the fact analysis? And if so, is that a coincidence, or is there something inherently harder in using AI upfront? So, for instance, preventing me from writing a bad contract that will come back and bite me when I'm in the middle of a due diligence situation, right? Ideally, I would want my data room to be filled with really good, meaningful contracts that wouldn't cause me to have to get a cut in my payment for my company, right? Also, when we look at due diligence, on e-discovery, ideally, I wouldn't want to use e-discovery software to find out that my salespeople had been colluding with the competition after the fact. Ideally, I'd catch them before they collude with the competition, right? So it's for both of you this question. Anna, maybe you can go first. Is there something inherently more difficult in using machine learning and AI more offensively instead of as defense, if you will?
Nothing technical, I would say. It's more of an organizational, a matter of status quo. This is how things have always been done, so this is how we'll keep doing them. It's a much bigger mindset shift to kind of, I mean, obviously, like the Saskin quote about whether you prefer a handrail at the top of a cliff or an ambulance at the bottom of the cliff. So we are very much, the legal profession is very heavily invested in being the ambulance at the bottom of the cliff, rather than doing things more proactively, and that's of course where it's not just about technology, but things like legal design, where you figure out new ways of doing things, and indeed doing things more proactively. But it can be difficult to justify and kind of also demonstrate that kind of to do things more proactively. It's not how things are done, and change management is awfully difficult.
What's your thinking, Noah? What is when do we see the first release of Kira that takes all that insight that you have in terms of which contract turns out to be problematic in the data room, and make sure that the first time the junior lawyer writes a draft that qualifies as something that would be red flagged in the data room, they are prevented from ever sending it to the other side?
I think that we will see increasing numbers of systems that are focused on document creation. For us, the problem that we were facing was just, and I think we are seeing, there are systems that help you at least negotiate contracts, but I think we will see contract drafting systems, and there already are those, like rules-based systems, for example, like a Contract Express or something like that, an AI under our definition that is helping you draft a contract. I think it can be tricky. I know you and I probably both find Ken Adams pretty persuasive on the idea that you can't just take a whole bunch of contracts, mash them. Yeah, you can't just take a whole bunch of contracts, mash them together, and all of a sudden get a perfect clause. So I think
you're likely to get the worst of everything, basically, if you do that.
Who knows? I don't even know if you're likely, but like you might get the worst, you might get the best, but
yeah, who knows?
Who knows what you'll get, right? So I find that that argument quite persuasive around you can't just draft a contract from a bunch of different pieces, but what you could do is you could take good clauses that you've seen and pull those out, or you could take problematic provisions, and if you see a problematic provision in an agreement, you could flag that to a supervisor, or flag that to another level of management within the company. So I think that type of thing we are seeing / will see more of going forwards. In e-discovery, I think it is harder. One of the things that I like about the problem that we're solving versus there's some really nice things about e-discovery problems. So I'm not, it's a very nice market where a lot of companies seem to be doing very well. So I'm not overall seeing the problems there. But I think one advantage that we have in contracts is that a change of control clause looks like a change of control clause, looks like a change of control clause. And it looks that way whether you're talking about a shipping company change of control or exclusivity versus exclusivity in a grain contract versus exclusivity in a financial services agreement. All of them look relatively similar, whereas fraud may look entirely different in different situations, right? And I think that makes it relatively hard to build a system that's going to spot when your employees are committing fraud or something like that. You might be able to spot something like even rules-based that's like there are competitors, and if you have a salesperson messaging with someone at a competitor, like maybe you should flag that. But that would probably be relatively rules-based, and you'd have to input the knowledge of like, here are companies that are problematic. I think in e-discovery, the situation that you're dealing with is that in a lot of cases, what you're looking for differs, right? Like maybe you could teach like a privilege detector in advance, but I don't know that would be super useful.
No, I think from a machine learning perspective, at least, your case is much more generalizable than the ones that you articulate. Oh, they would seem to be, at least from what you say, which is interesting. Marlene, am I right in saying that we might have a question from the audience?
Yeah, we do. And that will probably be our final question then to end up in this session with, and it's for the both of you. The audience are curious to know what legal technology tools you can recommend to students who studies law or who are or juniors who are just starting in their career at law firms. So people in in the first steps of their legal careers.
Can I just? I have to answer one thing. I can recommend this wonderful piece of legal technology called Microsoft Word. Learn to use Microsoft Word correctly, and invest in understanding it. You'll thank me later.
Martin, if they do that, then I don't have a job. Okay.
Yeah, see, I got the law degree without ever using Microsoft Word. I wrote all my papers with LaTeX, so...
Okay, well, there you go. But Noah, seriously, what would be something that you should take an interest in? Maybe, are you aware of opportunities to sort of get your feet wet in terms of legal technology as a student?
I think it's so specific on, there's different technologies for different use cases. Like you say, I think Word and Excel are pretty practically useful tools, though you can do a lot without them. I think if you're thinking about going into litigation, things like legal research tools are pretty useful to get to know. E-discovery tools might be fun to play with. If you're going to go into corporate law, something like Akira would be really good. And we actually allow free access for law students and even faculty. So if you reach out, we've set that up for a number of mostly US and Canadian schools, but we'd be happy to set it up for schools elsewhere if you reach out. So I think that would be really useful if you were going to be a corporate lawyer. Probably not so useful if you're going to be a criminal lawyer. And I think there's other ones for legal prediction software might be more useful if you're going to be a litigator. So I think it really is very area of law specific.
Cool.
Yeah, I agree that it's very, both in terms of where you are and what kind of law you want to practice. So I don't really have any practical experience of that's relevant. I mean, I would also like to highlight something that you can always try to keep track of your biggest frustrations with the technology that you end up using anyway, and then try to figure out better ways to do things. Of course, also using something like government IT systems, I think that's good for building up your tolerance for bad user experience, because that's definitely something you'll run into. So
is it a case, Anna, of if it doesn't kill you, it makes you stronger?
Yeah, something like that.
Yeah. Excellent. I think we're actually right on the mark. Yeah, we are. It's 1:00. I want to thank you both, Anna and Noah, for being here, and Noah for getting up so early. Go get a cup of coffee. You'll probably need it.
My next call's not for like 2 hours. I may go back to bed for a little.
Excellent. But thank you. I found this really interesting, and I really appreciate the fact that you were here to answer our questions and the questions of the audience. Marley, you have any closing words? Or?
No, I think this was a fantastic session. Thank you both for being here, and hope to see you in person soon.
Yeah. That would be very nice.
Cheers.
Yeah,
Thanks.
We'll be offline in just a second, I think.
Yeah.
Martinez should let us know.